Go ahead and get started and just welcome everyone in the audience. We will go ahead and begin our hearing on House Bill 2173 and ask our guest reviser for today, Ms. Natalie Scott, to give us a bill brief.
Thank you, Madam Chair. I assume you guys are all going to be very nice to me since Jason's not here today. House Bill 2173 authorizes certain offenders to petition for relief from the registration requirements under the Kansas Offender Registration Act. The bill amends KSA 224908. That's the statute that authorizes certain offenders to petition for relief from those requirements. Current law, it only applies to drug offenders, so those are the only category of offenders who can petition the court to get relief from those registration requirements. This bill adds a new provision that authorizes a petition for relief from registration for the following offenders, which I'll describe. If the offender has registered for a period of at least 10 years after the date of parole, discharge, or release, whichever date is more recent, or if they were not confined, at least 10 years from the date of conviction or adjudication. So the new class of offenders who'd be able to apply for this relief are offenders who were convicted or adjudicated of an offense prior to July 1st of 2011, that at the time of conviction or adjudication did not require the offender to register under the Offender Registration Act. But this retroactive application of this law did require them to register, or offenders who were originally required to register for a period of time, but because of the retroactive application of this law, were required to register for longer. And I can take any questions.
Okay, thank you. Committee, what questions do you have for the reviser? Representative Barrett?
Thank you, Madam Chair, and thank you for that brief. Just to go over, from what I can find, just to make sure I'm correct, what crimes this would include would be the non-aggravated version of indecent liberties of a child, criminal sodomy, indecent solicitation of a child, lewd and lascivious behavior, and sexual battery. Does that seem correct?
Madam Chair, I would have to go back. I can assure you that the proponents are going to know the answer to that, but I'd have to go back and see which crimes were affected by that law in 2011. But I know that Jen Roth will know that, so I'm sure she'll talk to you about it.
Thank you, Madam Chair, and thank you.
Representative Carmichael?
Thank you, Madam Chair. Does this apply to people who committed these offenses as juveniles as well as adults, or help me remember how that works, if you can?
Madam Chair, Representative, yes, it would. So anyone who in 2011, you guys made some changes to the Kansas Offender Registration Act. You applied them retroactively. And as a result of that, some people who were never required to register in the first place were then required to register. Some people who were already done serving their term of registration were required to register for longer. And so the retroactive application of that law did apply to some juveniles. And so those people would be able to apply for relief under this section as well.
Thank you, Ms. Scott. A pleasure to see you in committee. Thank you, Madam Chair.
Committee, other questions? Representative Schreiber?
Thank you, Madam Chair. Thank you, Natalie. Excuse me. How do they then petition the court to get relief through this bill?
Sure. Thank you. Madam Chair, Representative Schreiber. So the petition requirements are outlined further in the bill. You'll see in subsection D1, you can petition for relief from those registration requirements in the district court in the county where the offender is either required to register or where that original conviction took place. And you can see all the things that have to go into that petition. And then there's a hearing, there's certain notices that have to be required. The court will have a hearing. They can take into account certain evidence that's kind of outlined in this section.
Committee, any other questions? So Natalie, just to kind of confirm, this bill doesn't just get people off. Instead, it just gives them the opportunity to petition the court to end their registration requirement.
Yes, Madam Chair, that's exactly right. Yep.
And then just also for clarification, the reason this could be retroactive, the bill that we passed in 2011, was because that this is a civil penalty, because we don't do retroactive for criminal new laws, right? We don't go back, or how does?
Yes, thank you, Madam Chair. So yes, there's a general principle in criminal law that says you can't take a law that is going to be detrimental to the defendant and apply it retroactively. You can take laws that are going to be beneficial to a defendant and apply them retroactively. However, the Kansas Supreme Court has determined that offender registration is not a form of punishment. It's not a criminal law, it's a civil law. And so you guys are able to make those changes retroactive.
Thank you, that's helpful. Committee, anything else? Okay, thank you so much. I appreciate that. Committee, I'm going to do the order a little bit different. I'm going to ask Jen Roth to come up first, just because I think she may be able to offer some background information, and you would maybe have questions for her, more technical questions that the other proponents might not be able to answer. So Jen, thank you. Welcome to committee, and thank you for coming.
Thank you. My name is Jennifer Roth. I'm a deputy appellate defender at the through the public defense system here in Kansas. I've been testifying about CORA since 2006, and so I have a lot up here, but I also did bring a chart. But at any rate, I am here today on behalf of the BIDS Legislative Committee, and as it says in my written, well, actually it doesn't say this in my written testimony, but I was actually part of the Judicial Council subcommittee that you have testimony about from the council. So that subcommittee that I talk about in my testimony and in the Judicial Council's testimony, I was on that subcommittee, and I got to work with a great group of people for 2.5 years. And one of the recommendations that came out of that was an exit mechanism for everyone. And as Natalie's already mentioned, and as the proponent testimony mentions, you already have brought back an exit mechanism for folks who register because of drug convictions. So this would be a next step in the process. As Chairwoman Humphreys said, you have to petition. There's a process, it sets out a lot of rules about when you can do it, what you have to prove, et cetera. So this is not just an automatic thing. But I do want to back up and tell you a little bit about how we got here. And so the Offender Registration Act originally started in 1993, and it covered certain sex offenses. And then the next year, and it was for people who were second-time offenders. And then in the next year after that, they expanded it to people for first-time offenses, and it was still just for sex offenses. And so for a decade or so, there was an exit mechanism for folks that were on the registry. And again, it was basically sex offenses and kidnapping. And then over time, more and more people were added to that. And I have to admit that this is the shortest CORA testimony I've ever submitted, because usually I have a chart or something attached. But if anybody in the committee is interested, if it's helpful to you, I actually have a chart that shows you year by year what changes were made. And so at any rate, I was actually trying to look through it to answer the question about who all would have got caught up in 2011, and I'm going to have to do that here in a second. Sorry. At any rate, so what happened in 2011 is that the KBI led a working group that had met for a number of, year or two or something before 2011. And they formed this working group because they wanted to come up with changes to CORA so that they could comply with SORNA, which is a federal law. Now, the thing to keep in mind is that in 2011, we had drug registrants, we had violent registrants, and we had people that registered for sex offenses. SORNA does not care. SORNA does not deal with anything that's drug-related or even the violent things except for kidnapping for kids. So I want you to know from the outset that SORNA does not apply to at least 2/3 of the categories of this registry. So at any rate, the KBI had this working group. They put forward this bill in 2011, and they included things in it. As I said, they included categories that aren't covered by SORNA. They included recommendations that weren't even recommended by SORNA, so they went above and beyond SORNA. And then that bill passed. I actually represented the organization that was the only opponent to that bill in 2011. And a lot of the things I said came true, except for one that I'm going to talk about at the end. But at any rate, that is how we got here. And so I just wanted to be clear from the outset that this bill would restore an exit mechanism, including to folks who aren't even covered by SORNA. So at any rate, that's how we got here. And okay, so in my written testimony, I promised a couple different things. I wanted to talk to you a little bit about what SORNA what CORA requires. And honestly, I didn't get a chance to read the other proponents' testimony, so they are going to probably be able to speak a lot better to this about the real life impacts and things, but I just want to tell you that from a legal standpoint, CORA requires people to do things like, you need to tell us within 3 business days where you live, where you work, where you go to school, what cars you drive, what tattoos you have, what color's your hair, what jet ski you drive, what airplane you have, et cetera. And you have to report that information at least 4 times a year. And if you change it, you have to report those changes within 3 business days. Those requirements are for everybody, regardless of what you register for. And in 2011, one of the things that happened was before people had to register, depending on the crime of conviction or the finding, they had to register for 10 years or life. And in 2011, what happened is some people moved from 10 years to 15, some people moved from 10 to life, some people moved from 10 to 25, some people moved from no registration at all to life, or no registration at all to 15. So at any rate, I'm sorry I'm skipping around so much. But so you can read for yourself. In fact, you can go to the KBI's website and they have a brochure about who's covered by CORA, what it requires and things like that. I also brought my statute book. It's all in 224902 et sec. But what happens is if you fail to comply in any way with the Offender Registration Act, regardless of whether it's I didn't tell them that I got a new job within 3 business days, or I didn't tell them about the time I drove that car a couple times, then you can be charged and convicted of, at a minimum, a severity level 6 felony. That's the same as arson. And that's a person felony if you register for a person offense, and it's a non-person felony if you register for a drug offense or another non-person offense. A second conviction is a level 5, which is equivalent to involuntary manslaughter. And a third or subsequent conviction or omission or an act that lasts more than 180 days is a level 3, which is the equivalent of aggravated robbery. Now, you might be asking yourself, this doesn't sound like a civil regulatory scheme, which has been my position since 2006, that it's really not a civil regulatory scheme, but that is what our courts have told us, and I'm going to touch on that here again in a minute. So the thing is, if you don't report that information, let's say you forget, or let's say you had a baby, let's say you were in a Osawatomie. We have a case where a guy actually has a psychotic break, went to Osawatomie, so he didn't register, and he's got convicted. So it doesn't matter if you made a mistake, it doesn't matter if you were having a mental health crisis. Failing to register is a strict liability offense, and so you're guilty of a felony. It's that simple. So that's just a quick sort of context for why it is so important to give folks a mechanism to be removed from this registry, especially for folks who were told one thing when they got convicted and something much worse happened to them later because of the retroactivity of the 2011 amendments. One of the other things I mentioned in my testimony that I would talk about is how this affects people, but I can tell from the list of proponents, you're going to hear from people who can speak to that, and you don't need to hear it from me. But one thing I wanted to talk about before I shift to addressing any questions you have, but also some things in the neutral testimony, is the thing I told you about how in 2011 I predicted that a lot of things would happen, and a lot of things did. It swept up people. It ruined folks' ability to get jobs. It ruined folks' ability to do the pro-social things we want them to do to move ahead in life, et cetera. But one thing that didn't come true is that no court in Kansas has said at least for more than a day, that this is a criminal, that this basically functions as punishment, and that it can't be applied retroactively. So I just give you a story about that. We've argued that since 2011, but in particular, I had a case that I took over from one of my coworkers. This young man, when he was I think he's 14 maybe, he gets a juvenile adjudication for a sex offense. A juvenile adjudication, not a conviction. They don't try him as an adult. He gets a juvenile adjudication for a sex offense. At the time, the judge could order that person to register for 5 years, which is what the judge did. 1 month from him finishing that 5 years of registration, I can't believe I don't remember the house number, but the 2011 amendments took effect, and that person who was told when he was 14 that he had to register for 5 years, 1 month from being done, he was told, oh, sorry, you have to register till the day you die, and we don't have an exit mechanism. So we argued to the Kansas Supreme Court that surely that's punishment. All of that. And in the end, the Kansas Supreme Court said, nope, it's all good. So we petitioned that young man's case to the United States Supreme Court. In fact, I've petitioned 2 cases to the United States Supreme Court, and those both were denied. The last time that the United States Supreme Court has considered whether retroactive application of civil regulatory schemes like this is constitutional was 23 years ago. So I have faith that if there ever is a petition that's granted, that the U.S. Supreme Court will take another look at that and see that what exists now, especially in Kansas, is not what existed 23 years ago, and that it has arrived at the level of punishment. But I tell you that story for a couple of reasons, but the main one is because you're the only ones at this point who can right this wrong. I've tried in court, I've tried in district court, I've tried in state courts, and I've tried in SCOTUS. And you all, as the ones, not you all particularly, but as the legislature who passed this in 2011, I've exhausted my other avenues. And so it is only the legislature that can right this wrong. And that's what we're asking you to do. So I just wanted to, if you don't mind, I just wanted to talk about a couple of the things in the neutral testimony. And that is the KBI was talking about the burn grant money and how if you're not in compliance with SORNA, then you can lose grant money and that sort of thing. I just want to tell you a couple statistics. Number one, in 2012, which would have been the year after these amendments went into effect, there were 15 states that were in SORNA compliance. And now it's 13 years later, there's 18 states. And that's because states have realized that it is expensive to do what SORNA requires, or they have moral objections to what SORNA requires, or they're going to exercise their right to make their own decisions in their state about what their registry will require or not. And so there's 18 states since SORNA took effect that have decided to be compliant, and Kansas is one of those. It is true that if Kansas goes out of compliance with SORNA, that they can lose part of their burn grant money. The testimony says that that amount is $1,924,000. So what the testimony doesn't say, but you lose 10% of your burn grant money. So it's about, under $200,000 that you'd lose. And I'm here to tell you, I've got people that are doing time in prison that it's going to cost the state. One guy, it's going to cost the state almost $300,000 by the time he's done serving his sentence for some minimal violation of KORA. So I guess my point is, to be quite blunt, this idea of losing $200,000 means nothing if you look at how much it costs to incarcerate people per year and how many people are incarcerated. And you can get that information from the Sentencing Commission. So at any rate, the other thing I wanted to mention about that is that, again, this legislature has already taken a step forward by implementing an exit mechanism in 2022 for drug registrants. I haven't heard any reports that the sky's fallen or there's any negative fallout from that. In fact, I have gone to expungement clinics and helped people fill out paperwork to get removed from the registry, and it couldn't be more thankful. So I would like that opportunity to be extended to some other folks, and so I very much urge this committee to pass this out favorably.
Okay, thank you, Jen. Appreciate that. So, committee, we're going to ask Jen questions, but I think we have Representative Sutton is here. I think he has another committee meeting now, so I'm going to go ahead and let him testify, and then we'll come back to questions, Jen, if you can wait. So, Representative Sutton, thank you for coming to committee.
Thank you, Madam Chair, and I'm pretty sure the folks in elections aren't missing me, so it's no big deal. No, committee, this is probably one of the very, very few committees that I don't exactly feel comfortable testifying before. I've never practiced law a day in my life, and particularly on this bill, I would like to extend the warning to all of you that sometimes serving as a representative of your district could put you in a very strange position, arguing in a case that you never really thought you'd get involved in. But this is one. And let me tell you just a little story. In representing my district, I met a guy, and he might be an okay guy now. I don't have any real idea. I can tell you for sure that in the past, he was not a good guy. I did some terrible stuff. Served his time, got out of prison, I think either 2000 or 2001, right in that ballpark. Was told then that after 10 years, if he was compliant, showed up, did his drug tests and answered his questions and paid his, I think it's $20 a month, I think he's paying. But once he did all that stuff, if he did it for 10 years, he could be removed from the sexual predator list and could then, having satisfied his responsibility to society, he could then go about his life such as it was at that time. So lo and behold, 10 years later, we have 2011, and things changed. And well, not me, the body here at the time, even I haven't been here that long, the body here at the time changed the law, made it retroactive because it's civil. I get it. That did surprise me. When I first heard about this story, I thought, oh my gosh, this can't be true. Certainly this is just a mess up. We got to straighten it out. Piece of cake. I worked with the DA and so forth. No, that wasn't a mess up. That's what we did. So now it's been another 15 years. This guy is still on the list, still showing up every month or every quarter. I can't remember. He's showing up. He, by the way, is still clean as far as his arrest record is concerned. Since then, he's done a pretty fair job. But speaking of jobs, can't really get promoted. He's on the list. Has been evicted from several homes that he's renting at because he's on the list. So when I hear, look, I'm a tough I'm crime guy, don't get me wrong, but when I hear that the Supreme Court said that being on the list isn't punishment, how do you define punishment? Holy cow, this guy's life is trashed. Did he earn it? Yeah, we could make that case. Yeah, he probably did. But is that really the way that we want our laws to work? I'm not convinced of that at all. I don't think that's what we had in mind. Even maybe, I wasn't here, but maybe even in 2011, I'm not sure that's what we had in mind at that time. So looking at this, heck, if he petitions the court and they refuse him, that's one thing. That's not my problem. That's for him to deal with. I'm fine with it, and I wash my hands. But this, I think, is the right step. I think just giving an avenue, giving a chance, if someone really has straightened up, maybe it's not a life sentence. And if it is a life sentence, let's call it that in the beginning. rather than surprising someone down the road. So anyway, I'll stand for questions. I probably can't answer any of them, but I do urge your support for HB 2173. Thank you, Madam Chair.
Yeah, thank you. I think we'll just go ahead and see if anyone has a question now, so you can get back to elections, because I'm sure they're missing you.
I'm sure they are.
And does anyone, Representative Barth?
Madam Chair, Representative Sutton, I guess I'm just curious, you know, if we're looking at making a change, it would be helpful to know specifically for anybody who's testifying, what level of sexual offense was it? What are we talking about?
This was aggravated indecent liberties with a child.
With a child?
Absolutely. Yeah, that's what I said. This was not a,
The age of the child?
I do not.
Do you know?
And while I think he might have been, he's actually your constituent now, by the way, but thanks for redistricting. But yeah, I think he probably would have gone into details on that. He's never been exactly secretive about it, but I can guarantee you that I did not ask, and nor will I.
Thank you. Anyone else? Okay, thank you. We appreciate you being
Thank
here.
you.
Mhm. Yeah, we'll let you know that the testimony of Representative Sutton's past constituent is in your packet, so you can look for that. Thank you. We appreciate you being here. See, I think if you have technical questions about this, I think we'll go ahead and see if there are any questions for Ms. Roth. And go ahead and do that. And then we have several other, or a couple other private citizens that also want to speak to this. So what questions do we have for Ms. Roth? Anyone? Representative Williams.
Thank you, Madam Chair, and thank you. I feel like you gave a very good overview of it. I just have a few questions and probably some more specifics when it comes to making sure we're still keeping Kansans safe with people that should be on the register, should be on the offender registry. So when it comes to the court, this is appealed or a petition is brought towards the court, it has been past that 10 years. Can you bring me into a judge's mind as to what they're looking at to make sure that they have complied and have not been more of a threat to the community?
I can. So there is a, if I recall correctly, there, the language that's for the exit mechanism that we're asking to expand into, actually looks a lot like the language that you find in the expungement statute. And so, here we go. Okay, so if you want to look it up later, it's 224908. And so you have to file a petition, which under this language, you have to have registered for 10 years. And then, so you have to say things like, what was your name at the time? What do you register for? If you have been arrested, convicted, or adjudicated, or been on diversion for anything during the last 10 years or however long you've registered, the names of treatment providers you might have had, and then the court, you know, the DA gets notice of this, the victim gets notice of this, they can come to the hearing if they want, they can ask for a risk assessment, the court can ask for a risk assessment, and it has to be paid for by the person that's seeking the removal. And then the court orders relief if the registrant shows by clear and convincing evidence that they haven't been convicted of a felony other than a core violation, because those are easy to get. But you haven't been convicted of a felony within the 5 years immediately preceding this petition, that the offender's circumstances, behavior, and treatment history demonstrate that the offender is sufficiently rehabilitated to warrant relief. Registration of the offender is no longer necessary to promote public safety. So, and then the court, if they deny it, the person can apply again, but they have to wait. This says 3 years unless the court gives them a shorter amount of time. So there's definitely things that you have to produce before you even have your hearing. And then there's certain findings that the court has to make. And I would just tell you, that clear and convincing evidence is the same amount as to take your kids away. So it's a very high standard. So that is sort of in a nutshell what would have to happen.
So like if in a case, the 10 years has passed, there's been no crime convicted, but say the offender did not complete a court-recommended recidivism or treatment program, they would take that into account?
Right, I mean, yeah, because I'm sort of paraphrasing here. I mean, I'm gonna guess that in real life, when this happens, there are gonna be all kinds of stuff that's asked for, depending on the offense, but that there'll be all kinds of things asked for, maybe old records and things like that. But you're right, one of the provisions in here is that a court can make a person get an assessment.
And then can I ask another one? When it comes to out-of-state people who are on register, or the crimes are committed out of state, I noticed that there was some language in there that said that there was a different process for out-of-state registrants.
Right, so if I recall correctly, the bill says it doesn't cover people, well, if you have to register in that other state, then we're gonna honor that from the other state. And CORE has always been like that, where they say, you register for as long as we say, or the other state, whichever is longer. So I can't remember the exact language, but you're right. There's something that wouldn't let us undo other states' things, if I'm remembering correctly.
Okay, that makes sense. And one last one, if you would allow me. So then, as we're looking at it as a whole, does the court take in like violent sex offenses with that? I just think from like, so say something violent and it's listed, I don't know, is a tier 2 sex offense a violent offense?
We don't tier them in
Okay.
Kansas. That's a SORNA thing.
Okay.
So I'm going to guess that, or not guess, hold on here. I'd have to read this again, but I'm going to wager that a court would definitely look into what the underlying facts were, but maybe even let the person, if the victim's still alive or is interested, there's a provision here that says that the victim won't be compelled to testify or provide anything, but I'm going to guess that if that person wanted to say something, that the judge would let them say something.
Okay. Thank you. Thank you, Madam Chair.
Any other questions, committee? Representative Barrett.
Thank you, Madam Chair, and thank you for coming to the committee. Just from my understanding, so based on what I've read and what I've looked up, this is going to be for non-aggravated crimes, and this is for only for individuals who were set up with that 10-year registration period. So those who had the lifetime already for those aggravated offenses, they're not included in this.
Yes, I'm glad you said that because I thought it was your voice, but yes, so I tried to look at my chart and you're right. As early as 1999, CORA was changed to make it so that people are convicted of an aggravated offense, which is, I think, defined in a little bit different way than aggravated as it's the title of things. But it says if people are convicted of aggravated offense, then they register for life. So those folks were already lifetime. But one thing that is not occurred to me, maybe they never could be petitioned. I'm going to send you this chart because I'm wondering whether those folks ever had a chance to petition. So I'll just send you this chart. But to answer your question, that's correct. Those folks have been lifetime since way before 2011.
Thank you, Madam Chair.
So just to clarify, this bill is only the folks who would have been getting off or weren't on at all, and then it retroactively added. So it's this group of people that were caught. So whatever offense it was, the court thought 10 years was adequate back when they...
The legislature thought 10 years was adequate, or the legislature thought 5 years if you're a juvenile, and that was, you're right. I mean, in my perfect world, I'd want this to apply to everyone, but yes, it only applies to people who got caught up in those 2011 amendments.
Okay, yeah, thank you for that. Representative Carmichael.
Thank you, Madam Chair. Ms. Roth, I always appreciate your perspective. I I believe you've had an opportunity to review the testimony of Mr. Stewart from the KBI regarding financial impacts of possible noncompliance with SORNA. Do you stand by what you just told us a few moments ago about the maximum possible penalty of roughly $200,000? Or is there more that Mr. Stewart's testimony points out?
So
That's a bad question, but help me with it.
Right, so I just was reading it on my phone, but these are the sorts of things that jumped out to me. Number one, forever, it's been 18 states or fewer who have complied with this. So then what happens is you lose 10% of your burn grant money if you do not, if SORNA finds that you're not in, or the SMART office finds that you're not in compliance, your state's not in compliance with SORNA. And so 10% using the grant, a full grant amount to the state of Kansas or something from the year in the testimony, that would be under $200,000 that we would stand to lose by losing 10% of our grant money. Now, I cannot speak to the fact that it looks like the KBI has applied for some other grants, but I don't know if SORNA would say, I don't know. The other thing that to keep in mind is that there are a bunch of people on our registry that SORNA does not even deal with. So I've always thought that sort of played into it too. Like, at any rate, I don't know if there's a way that if KBI would lose that grant money, well, they haven't lost it, but the grant money they're applying for to do something more to their system, I don't know if they would lose that opportunity if SORNA found that we were in non-compliance. But again, I can say that's a $200,000. And honestly, I can also say that if in fact the grant was for $600,000 or whatever it said, that again, the state of Kansas spent over $9 million incarcerating people for 1 year that had been convicted of KORA violations in fiscal year 23. So I bet we can get that money somehow.
Thank you.
Any others? Thank you. Oh, I'm sorry, Representative Vaughn.
Thank you, Madam Chair. I'm still trying to kind of understand the connections between SORNA and KORA and how those are related today. So was the 2011 update based on the minimum requirements to be compliant with SORNA, or is it more punitive than SORNA? And then if these changes are made, how would that make us out of compliance with SORNA?
So it's, okay, so what happened is in 2011, the working group said, you know what, it's just easier to treat everybody the same. So all of the amendments that applied retroactively, as far as extending the length of time you register, what you have to, information you have to provide, the penalties, et cetera, all of that applies to any kind of registrant, whether they're drug, sex, or a violent category. And then the working group made some recommendations that went above and beyond SORNA, even for the sex offense part of it. So granted, none of that stuff counted for 2/3 of the categories, but even for the recommendations that SORNA requires for sex offense things, it went above and beyond that. For example, here's one. SORNA does not care to have people register for life for, or at all, for kidnapping of an adult. And we make those folks register for life. So, so at any rate, I don't know if that answered your question or not, but so I guess what I'm trying to say is that even in 2011, the working group went above and beyond SORNA on sex offenses, and then those other two categories don't even have anything to do with SORNA.
Yep. Go ahead.
Thank you. I think that answers the first part of my question. For the second part, so if we were to make these changes, so because the actions of the working group were above and beyond what SORNA requires, if we were to do this, how would this make us out of compliance with SORNA?
Oh, sorry.
Does that make sense? Sorry,
Right,
does that make
yeah.
sense?
It's because that SORNA does require registration periods of certain amounts for certain offenses. And so and I mean, maybe, and honestly, I don't know the answer to this. They, I don't know if they they don't let everybody petition to be removed. There are some people under SORNA that could be petitioned to remove that we don't allow. And so that might be how we fall out of compliance, because we're not saying that anybody has to stop registering. We're just changing that some people are able to ask for, removal. And the other thing is that I don't know about is whether SORNA You know, they only got 18 states. They have a lot of tribes, but they only have 18 states. So sometimes I think they might work with states, but I don't know if they would work with us. I don't know. But they do, you know, they have different lists. If you went to the Smart Office website, they would show you like, you know, these people are in substantial compliance, these are people are close, you know, or whatever. But that's the problem, is that it would allow some people to be removed from the registry, and I think that's what SORNA doesn't want.
May I ask one more?
You know, I think we're going to move on.
Okay.
And maybe when the neutral conferee comes in, then you could maybe answer. I think we need to move on. We've got
No,
we've
I'm
got a few
sorry.
other, that's okay. We've got some other things to do.
Thank you for your time, I appreciate it.
Yep. Okay, so thank you. I will go ahead and call up Jana Burnside, private citizen. Welcome to committee. And, you know, we're thinking 2 or 3 or 4 minutes. I don't know how long your testimony is.
Yeah, I practiced it a little bit and it was
Okay.
2.5 minutes. Then it
Okay.
became 4 minutes. So let's say maybe in between. I don't know.
Okay.
Good afternoon, Madam Chair.
Glad to have you.
And others on the committee. Appreciate the opportunity. My name is Jana Burnside, and I'm here with my husband today, or he's with me, however that works. We are in favor of House Bill 2173. We're from Garden City and are both lifetime Kansans, or have been lifelong Kansas. Anyway, I know you've had an opportunity to read the letter of testimony that was prepared and sent, written letter, and I don't want to read that to you because you've got access to it. And I'm going to mention a few key points, but a lot of them, you know, have been covered by some of the others. So hopefully I can kind of skim over that since you already understand that. We'd like to share, first off, our personal connection with the situation is our youngest son, Blake, was arrested of electronic solicitation in 2007. Well, he was convicted in 2008. And he was one of those that was in that window at the 2011 amendments to the laws that pertain to the registered sex offenders. And so at that point, his 10 years became 25 total, 15 were added. By the time he would be finished, he'd be 48 years old, and that would be in 2023. He'll be 40 this August. We just feel like extenuating circumstances on his case, never had a conviction before, one-time offense, no conviction since, complied with all of the sentencing guidelines, was released from probation early. The job issue that you mentioned is a very good fact. He's had 2 long-standing jobs the entire time since the arrest in Garden City, 2 different businesses, local businesses. One of them is a statewide. And in that particular one, he had an opportunity to get a new job in another city in Kansas. It's a company that has several businesses. Was offered, accepted it verbally, and spent 3 long months all summer trying to find a place to live, and every single housing application after housing application came back denied because of the registered offense. So he had to reject the opportunity to move and stay put because of this. And I'm sure that happens a lot. It's not just him. That's just a good personal example. And we had lots of friends, family, and people that had connections that were going to try to do their best to make this work because they were going to stand on a character reference that he'll be fine, he'll be fine. But the laws surrounding their ability to rent are problems for them. They become liable if there is a problem. So that was washed out the window. Anyway, we really feel like he's just that example. He and many others, I assume, across the state that fall into this same category. It seems only right and fair that we offer some sort of an avenue for them to at least be considered if they've done their time and have an opportunity to follow through with that process. The other thing I know that has been covered was about this Kansas Offender Registry list. If it does pass, hopefully, and prayerfully becomes law, they won't be released automatically. You know, what will happen is they have to jump through all the hoops, have to prove themselves worthy, have to have complied with all of their other sentencing guidelines, which our son has. But we feel like that will make it an available opportunity if they've proven themselves to be worthy of consideration. And then they do have to file the petition, and it all has to be accepted. This is just the first step. We understand that, but it's very, very essential as far as we're concerned. Also understanding the significance of supporting this bill, it's just going to help create the opportunity for them to initiate the process. It's not going to say you're scot-free. This has been put in place. You've waited a long time. Here are the next steps. No other convictions, no arrests, no other law-breaking issues. These are law-abiding citizens to the best of their ability since they were young men. And I feel like it's just going to give them an opportunity to have a real meaningful chance with real success in life instead of just kind of going through the motions. I guess that's the best example I can say. What we want to do is encourage your passing of this bill, of course, in the House when it hopefully comes to vote. We want to encourage you to talk it up with the Senate side to make sure it's there that they can pass. And it is a viable solution. This particular bill produces, to me, a very realistic and reasonable answer to the problem that I think has been presented to folks since 2011. And didn't know it happened, but we got the letter afterwards from the KBI that our son was sent that, guess what? You're now going to have to add 15 years to that registry, even though you've been doing the best you can do. I don't think there's anything else I have. I have my little note cards, and my husband said, be sure and don't drop those. It'll drive you nuts because you'll get mixed up on where you are. I really think that's pretty much all we have to cover. We really do appreciate your interest in not just this bill, but in the Kansas laws. I mean, it takes a lot of commitment and effort, and appreciate your time and opportunity for us to offer our verbal testimony. Thank you very much.
Thank you for being here. We're going to go ahead and hear from the other proponent, and then if anyone has questions for either one of you, we'll do questions then. Okay, Andrew Parrish, you would come on up. Welcome to committee.
Thank you. I only learned about this hearing late yesterday and had very little time to prepare, and I'm not a naturally eloquent speaker. So I prepared a testimony. I would like to just read it because I think it captures my thoughts better than if I were to just speak. So I believe that all of you have a copy of this. It is what I'm going to be reading is the copy that you have. My name is Andrew Parrish. I am 37 years old, and I have been a resident of the state of Kansas for most of my life. In 2006, at the age of 19, I was arrested for events that took place in 2003 and 2004, and 1 year later convicted via plea bargain of attempted indecent liberties with a child, as well as attempted solicitation of a child. I was sentenced to 3 years of supervised probation, completion of a sex offender treatment program at Prairie View Health in Newton, Kansas, and registration on the Kansas Sex Offender Registry for 10 years, to be removed from the registry in January 2017. Importantly, and worth note, the court determined that I was not a sexual predator and I was spared incarceration. I was grateful for the opportunity to avoid jail and committed myself to completing my probation without incident, as well as successfully completing the treatment program. I was determined to become a better person. Over the next several years, I attended treatment 6 times a month while working as an HVAC installation technician, installing ductwork in residential new construction. During this time, I was blessed to marry a woman who saw my potential and believed in my ability to change and grow, and she stood by me despite the hardships we faced. She is here today. Together, we started to build a life, and we became young parents to our first child, my son, Judah. Even with the joy of becoming a husband and father, life was challenging. The financial cost of treatment was high, and the housing market crash of 2008 left me struggling to find steady work. My conviction made employment nearly impossible, limiting me to inconsistent work as a handyman or day laborer. Holding a steady job was nearly impossible as background checks and registry requirements led to frequent job rejections. Yet my wife and I held on to hope. I was seeing tremendous growth from therapy and learning things about myself and my childhood that I had never before dealt with or faced. And we clung to the hope that in 2017, when I was removed from the registry as originally ordered, opportunities would finally open for our family. mainly steady work and an income that could support our growing family. However, in 2011, Kansas passed new laws retroactively extending my registration from 10 years to a lifetime. My sentence was altered after the fact, and the hope that had carried me through those difficult years vanished. The impact of this decision has been devastating, not only for me, but for my wife and children. For the past 18 years, I have gone to my local sheriff's office every 3 months and filled out paperwork and have had an updated picture posted to the internet. I have lived with the stigma and restrictions of the registry. I have been turned away from countless job opportunities despite being qualified or even overqualified. I've had my membership to gyms revoked simply because of my name being on the registry. I've been unable to coach my children's sports teams, take them trick-or-treating, or even attend certain school or church events. I've been denied entry onto flights because my destination would not allow me to enter. In 2009, in the hope of finding steady work, I went into an Army recruiting office only to find that that too was barred to me. I'm limited in travel, unable to teach my children to hunt, unable to donate blood, and unable to vote or serve on a jury, civic duties that I deeply believe in. I have lived in fear that neighbors will discriminate against my family, or that my address will be flagged as a danger simply because my name remains on this list. I worry that one day a coworker or employer will find my name on this registry and it will cost me everything I've worked hard to rebuild. To most people, their opinion of me is limited to the convictions they read on the internet and not based on who I am now as a person or how far I have come from that teenage version of myself. They do not take into consideration all that I have accomplished over nearly 2 decades of hard work and determination. Accomplishments that I am not only proud of, but also I believe show that I have become a productive member of society. I am now the father of 4 children, all boys, and yes, the medical bills of 4 boys are second only to the grocery bills of 4 boys. I've become an active member of my church and local community with character references from pastors, police officers, lawyers, and business leaders. I started a business that ran for 7 years, creating jobs in the Wichita community, and am currently employed as a sales manager in business-to-business sales for one of the largest HVAC and building solutions company in the world. I have done everything I can to better myself and overcome the barriers that lifetime registration has put before me, yet the registry remains as an ever-present threat to the continual growth and progress in mine and my family's journey. I have spent 18 years proving that I am not a threat to society, yet I continue to be punished for the sins of my youth. Had the terms of my original sentence remained intact, I would have been removed from the registry in 2017, and my family's life would look very different today. I have never reoffended, never even been accused of a new crime, yet I still carry the label as a constant threat to the safety of our community. I share my testimony today because I know my story is not unique. Thousands of people across our state are trapped in a system that has drastically reduced the possibility of redemption. The registry, as it currently operates, does not distinguish between those who have been rehabilitated and those who remain a risk to society. It does not consider personal growth, commitment to change, or years of law-abiding behavior. Instead, it permanently brands individuals with a label that strips them of opportunities, dignity, and the ability to fully reintegrate into society. To be clear, I am not anti-registration, anti-justice, or anti-protection of children. I believe in these things in the context of being pro-second chances, which I am. I am also pro-rehabilitation, pro-redemption, pro-change. I am pro-reform. I am pro-common sense law that both protects the innocent and offers redemption to those willing to work for it. Members of this committee, I urge you to support meaningful reform that restores hope to those who have worked tirelessly to rebuild their lives. Rehabilitation should be the goal of our justice system, not perpetual punishment. Please consider the impact that lifetime registration has on individuals and families who have already served their sentences and proven their commitment to change. Thank you for your time and consideration. I would also add, if I may quickly, I realize I might be speaking of things above my pay grade, as it were, but listening to some of the conversation today, I would urge you not to make a decision based on whether you receive or lose grant money. This should not be a financial decision. This should be about rehabilitation. This should be about reform. This should be about making our community a better place and giving, my children the future that tells them if they make a mistake that there's hope. It's not the end. So I would urge you also to disregard the possibility of losing grant money, especially a trivial sum, over something so important. Thank you.
Thank you, Andrew. We appreciate your words. Committee, do you have any questions for Jana or Andrew? Okay, thank you. We appreciate it. Committee, I will draw your attention to other proponent written-only testimony. Nancy Strauss from the Kansas Judicial Council has interesting testimony. Chris, Cindy, Ann, Keith, and Annette, who are private citizens that have personal stories that you would be interested in reading about. So I will close the proponent piece of the testimony, and we don't have opponent that I know of, and call on Bob Stewart from the KBI for neutral testimony. Thank you. Welcome to committee.
Madam Chair, members of the committee, my name is Bob Stewart. I'm the executive officer. I'm the tall one. I'm the executive officer for the Kansas Bureau of Investigation. I've also brought one of our subject matter experts, Ryan Hansen, who can answer questions that sound like are going to get deeper than I'm capable of answering, should you have them. I'll try and be real quick. As you know, this is neutral testimony. The KBI does not have a position to declare to you about whether an exit strategy should be made, whether any changes should be made at all. That is certainly within your purview, and we will honor that purview however you make it happen. We did want to make sure you understood that there were potential ramifications if you make those changes. The Appellate Defender's Office has done a fantastic job sort of articulating what most of those are already, and that it really is limited to the SORNA element or the sexual crimes element that would cause us concern. The grant issue does lay out an issue that any change in the status of Kansas statutes will in fact cause it to be readdressed by the SORNA committee. SMART is the committee that reviews it. I included in my testimony their checklist. Their checklist is a 24-page checklist. The full brochure, the full write-up is an almost 200-page write-up about what you need to do to be in compliance with SORNA. While I certainly applaud the zealous advocacy of the appellate defender, there's one thing I would take a little bit of issue with. Although historically, a punishment for not being in compliance with SORNA would be a 10% hit, she's correct. We are experiencing now that the Department of Justice is using the burn grant funding as a hammer for compliance. And they're not required to stay at that 10% if they find a compliance violation. They are starting to articulate situations where they may refuse any burn grants. So again, we don't know that. It's just something that we wanted to make sure the committee understood was a problem and a potential issue. The second grant issue that I mentioned in my testimony was certainly regarding ks.gov. ks.gov is the Kansas offender registration tool. It is something that the KBI cobbled together from FBI software. Our sheriffs use it, and it's quite frankly old and it's fallen apart. We have asked for enhancement funding from the state. So far, the governor and the appropriations bodies have approved that, and it's $500,000. That would sort of partly solve the problem, but we are making a grant request of the Department of Justice for $600,000 more to make that a complete package that will meet the needs of the sheriffs and the communities in Kansas. We suspect that these changes in SORNA will certainly flag us. It doesn't necessarily mean we won't get it. It doesn't mean we will, but will flag us for further review that might make it difficult to get that grant. And of course, the last point that I would mention is that if this bill is enacted, we do have a fiscal a note that's attached to it. So with that, I won't take any more of your time. If you have any questions, I can answer, certainly that Ryan can answer. We stand for those.
Thank you so much, committee. Okay, Representative Vaughn.
Thank you, Madam Chair. So, I mean, just based on your remarks, it sounds like there's no certainty that this would actually bring us out of compliance with SORNA. It's just a possibility.
It certainly will change. Every year, we're required with the governor's office to say, hey, we're in compliance. We don't make that call, they make the call. So we will go through that checklist, and we've highlighted a couple pages in that checklist on page 18 where we're going to have to show variance if this law passes compared to last year. That will flag it, and then they will make a determination whether we're in compliance or not.
Thank you.
Representative Carmichael.
Thank you, Madam Chair. First, just a procedural matter. For whatever reason, I can't seem to open the attachment to your testimony. I'd hope you can get it to me and we'll talk afterwards because I want to be able to look at the checklist.
I should have attached a paper copy.
No,
But you want the electronic copy? I'll make sure I get it happen.
We'll get that worked out.
Yes, sir.
My question, though, is in looking at the fiscal note that has been prepared by the KBI, it talks about having two additional FTEs, I think, if
Yes,
I
sir.
read it right. But it doesn't seem to have an offset for not having to maintain as many, or excuse me, not having to handle as many registrations. It seems to me if you reduce the number of registrants, you can save money by not having to administer the program for these people that are going to get off the list.
That's a fair assumption. The initial side administration is borne by the sheriffs. Once that gets through to us, we're monitoring that. We hold the data, we capture the database, and we make sure that it's being tracked as well as we can. But the cost at the front side is at the sheriff's level.
My opportunity to question is limited. Thank you, sir. I'll look forward to visiting with you after the hearing.
Thank you. I will note too that we do have a, not just a fiscal note, but we have the bed count note from Scott Schultz, who does mention the impact of prison population. So you should take a look at that also. Representative Osmond.
Thank you, Madam Chair. Representative Carmichael actually asked the exact question I wanted to ask.
Okay. Any other questions? Okay, thank you. We appreciate you being here with us.
Thank you, Madam Chair.
And if you may try to
I will make
send
sure
that to
everybody
make sure
gets
everybody gets it.
So
Yeah.
a copy you can open.
Okay, all right, thank you so much. Okay, committee, I will close the hearing on House Bill 2173. And now we're having an informational hearing on the Kansas Limited Liability Companies LLC Act. And our main informant, I guess you're not a conferee or proponent or opponent, but will be William Quick from the, the study committee from the Kansas Bar Association. And again, committee, the reason we're doing this is because we will have this bill next week. It's quite lengthy, it's quite detailed. And so this is to help us have an expedited hearing next week. So Mr. Quick, welcome to committee, and please go ahead with your presentation.
Madam Chair Humphreys, is everyone able to hear me?
Yes, we are.
Okay, great. So as you mentioned, we're here representing the Kansas Revised Limited Liability Company Act Study Committee of the Kansas Bar Association. I am here, my name is William Quick. I'm an attorney at Polzinelli. I'm the chair of that committee. We also have Bill Matthews, who's with the Fulston Siefken firm. He is here to speak on this matter as well. I also want to note that Clay Barker and Jameson Beckner with the Kansas Secretary of State's office have been involved with our committee, as has Professor Amy Westbrook with Washburn Law School, Rebecca Miller with the Central National Bank, and Professor Alex Platt with the University of Kansas Law School. We appreciate the opportunity to speak with you today and give you a little background and context as to why we're proposing these revisions to the Kansas Limited Liability Company Act. I'm going to speak briefly just to give you some background and context of our process and why we're here. our committee with the Bar Association takes a very proactive approach with the business statutes in the state of Kansas. We want to make sure that we are a very business-friendly state, that our laws are at the forefront of business laws so that we can encourage companies to come and operate in the state of Kansas, and that we have an efficient, effective mechanism for operating those business entities. So one of the decisions that the Kansas Bar Association made about 50 years ago is that we generally, with respect to the business statutes, follow the precedent of the state of Delaware. And Delaware is kind of known as the gold standard of business entity laws throughout the U.S. And they have, that's evidenced by the huge number and size of corporations and limited liability companies that are formed there. Delaware also has a special court, their Court of Chancery, that hears only business cases. So they have judges in Delaware that are specialized and have expertise in interpreting business statutes and cases that come before them. As a result, Delaware has a huge volume of case law that is processed through their courts each year. Kansas generally does not have a lot of case law with respect to business entity situations. So by our following Delaware's precedent, our courts and our businesses are able to have more informed and robust understanding of how the laws operate, and also have the benefit of the most up-to-date enhancements and revisions to the law without having to have a lot of cases decided in Kansas. And it's a huge advantage to us. It's a huge advantage for our business community. So I just explained that to you because what happens from our committee's perspective is every few years, we will go back and revisit the laws in the state of Kansas in relation to changes that have been made in the state of Delaware. And Delaware each year has updates to their statutes that are informed by cases that have been brought in Delaware, also changes in the business community generally. So there are annual changes made in Delaware. We, on the other hand, will kind of go and revisit this every several years. So we did an omnibus bill similar to the one that's in front of you today back in 2019. So that was 6 years ago. So what our committee has done is we have looked at the changes to Delaware's law between 2019 to the present, compared it to our statutes, made decisions as to whether it would be appropriate for us to make revisions to our statutes that are either in conformance or similar or influenced by the decisions that were made in Delaware. We don't have 100%, rubber stamping of what Delaware has done, but Delaware's actions do have a significant influence on our understanding of our own laws and how we approach them. So what that results in is every several years, in this instance, 6 years, we come back and we have kind of a fulsome review of our statutes, which is also informed by, things that come before Bill and I as practitioners or before the professors at the law schools when people come in and say, hey, there's this glitch in the statute or it doesn't work well, or the Secretary of State comes in and says, we've got this recurring problem. Can we address it? So all of those things get brought together and we address them in a holistic manner. As a result, you've got I think it's an 86-page PDF red line in excruciating detail about all of the subtle nuances and changes that we're proposing. Other than business wonks such as Bill Matthews and myself, most people probably are not excited to be reading through that type of information and analyzing it. But I give you that as kind of background so you understand, why we're here, why you have this huge volume of information, and what the kind of context is. So I'm going to take a short amount of time to in an abbreviated, high-level manner, talk about the changes to the statute that are contained in those 86 pages that you've got in front of you. And then I'm happy to answer any questions you have. Bill Matthews is here in particular to answer any questions with respect to the Series LLC portions of the statute, but he's also well versed with all of the rest of this too. So I think between the two of us, we should be able to address any questions that you have. So getting to it, there are a number of ministerial clarification revisions, corrections, cross-reference adjustments in the Act. These are kind of clerical fixes that have been brought to our attention over time. One more substantive change is that we've added two new definitions, two new defined terms to the statute. One is the term document. The other is the term electronic transmission. These changes were made to address the changing realities of businesses and their operations and the use of electronic communications and transmissions. So there were a couple places in the Act that talked about electronic transmissions previously. Those instances have been redacted out and deleted in favor of a more holistic approach. This is kind of conforming with how Delaware addressed these changes in their statute. So now we have a defined term document, whereas before it was never defined because everyone understood what a document is. Well, the only change to what we all understand a document is now is that it also includes an electronic transmission. So we're not just talking about things on paper, we're talking about electronic records. The electronic transmissions, give some definition to what we're talking about when we talk about electronic transmissions. That same information was embedded in different parts of the statute before. Now it's just been pushed up into a defined term, so it's more consistently applied. Second item, there are, throughout the Act, I think Bill mentioned there to me earlier today, there may be like 16 different places this shows up in the Act. There are references to series limited liability companies. And I would love to talk to you about series limited liability companies for an hour or 2 hours, but I suspect that most of you don't really care what series limited liability companies are. So I'm not going to go into a huge amount of detail. But I will say that a number of years ago, we as a state adopted a series LLC portion of the statute. Series LLCs are, it's hard to define, but it's kind of like a division within an existing limited liability company that can operate independently from the rest of the limited liability company. There are a number of different ways and approaches that different states had adopted in dealing with these. Ironically, this was a situation where our committee deviated from Delaware and followed something similar to the Illinois model rather than the Delaware model, and had a series limited liability company that would require a filing with the Secretary of State to actually establish a series associated with a series limited liability company. Ironically, between when we adopted that in 2019 and present, Delaware kind of came around to where we were on that. So we had the foresight in that instance, and Delaware is going to come around to our thinking. In Delaware, who had historically had what was referred to now as a protected series, adopted a new option for series. It's called a registered series, in which you could register the series with the Secretary of State by making a filing. And that mechanism closely aligns with what we had from the inception of our Series LLC Act. So Delaware's going to come to where we're at. We, as a result, looked at the changes that Delaware made to their act having to do with registered series, which is akin to what Kansas has, and made some changes to our statute that conformed with Delaware's that we thought were useful and helpful. There are a number of other kind of spot issues that we adopted. One, void or voidable actions may be ratified by the members and managers of limited liability companies. If you're familiar with the Limited Liability Company Act, it defaults to a great degree to the ability for the parties in interest to contract for whatever they want to have. And that contract is generally referred to as an operating agreement. So a lot of the act allows for people to make decisions in their operating agreement and not just be subject to whatever the statute says. So one of those items had to do with void and voidable actions having the ability to be ratified. There is a section that has to do with mandatory indemnification of certain parties for acts that they're doing in their official capacity. That generally had included members, managers, officers, employees, and agents. We removed the "and employees and agents" portion. That change aligns with some revisions that we made to the corporate statute several years ago when we had a similar omnibus update to the corporate statutes like we're having today with the limited liability company statutes. So both following Delaware's lead and also conforming and being consistent with other existing business statutes that we have in Kansas, we made some changes to that situation. We also made a change that talks about the fact that there are no statutory appraisal rights. And this change corresponded in some degree with this change to the mandatory indemnification. But what it says is, hey, you can provide appraisal rights in your operating agreement, but there's no appraisal rights in the statute. So that was kind of a clarifying change tied to the indemnification change, again, following with Delaware in consistency with some other business statutes that we have. We provided some clarification language regarding the merger or consolidation operations under the Act. We made some changes having to do with the division of limited liability companies. A division of a limited liability company is kind of a merger in reverse. So if you have in Delaware and Kansas are one of the very few states that have this option. I think it's a great option. But you can effectively break an existing limited liability company into different pieces and then have them each go forward as independent business entities from the original entity. So there are some changes in the statute having to do with that division process. There were some changes having to do with what records may be accessed by members and other people in interest with respect to a company. There were delegation of powers in conflicts of interest provisions that we made some adjustments to. There's a provision that says that if a subscription document says that it's irrevocable, it's irrevocable. We put a cap on some Secretary of State fees that may be charged for certain filings that the Secretary of State's office makes. The Secretary of State office representatives came to the committee and said, hey, we think we can be more efficient and cost effective on some of these filings. Right now, we're just obligated to charge $150 for certain filings. We would rather have that be a cap and we can charge less if we can do it for less cost. So we thought that was a great, attitude and mindset from the Secretary of State's office that they want to be efficient and pass those savings on to the business community. So those changes were included. There were some changes having to do with statutory public benefit limited liability companies, which are kind of, similar to a statutory public benefit corporation. Again, I'd be happy to talk for an hour or 2 hours on that, but I suspect that Bill Matthews and I probably would be the only ones still on the Zoom at the end of that time period. So we will, restrain our enthusiasm toward that. There were some revisions that were made having to do with merger timing and amendments that you could file for a merger in anticipation of getting the approval for the merger, but you still couldn't merge until you had the approval. So that was, a very wonky, nuanced change having to do with just the practical application of the statute in the context of, doing mergers of limited liability companies. And then the last changes had to do with resident agents and allowing, first of all, that if you have an entity that is a registered or a resident agent, that entity has to maintain its good standing in Kansas. And also some provisions that had to do with conversion or division of an entity that is serving as a resident agent and how that would happen. So I think maybe I need to clap my hands so that people wake up from the stupor of what I probably induced in going into these details about the Limited Liability Company Act. But I'm happy to answer any questions. Bill's happy to answer any questions. I will say, we have a lot of people that deal with businesses involved in this process, and we try and keep everybody in the loop so that the main constituents' voices are heard. The Bankers Association participates in the process. The Chamber of Commerce participates in the process. The law schools participate in the process. The law firms participate in the process. The Secretary of State's office participates in the process. So with that, let me open it up to any questions you might have.
Okay, thank you, Mr. Quick. We appreciate that. We're going to go ahead and hear from actually the Chamber and the Bankers Association. And if you don't mind waiting, we'll see if there's any questions. But I really do appreciate that thorough explanation. I know it will help next week when we actually have a bill number and we're able to have a hearing on the bill. So thank you for that. Okay, I'll call Eric Stafford up from the Kansas Chamber. Just note, he's also just part of the informational hearing. We don't have proponents or opponents today on this, but Eric, welcome to committee to give us a little more information.
Thank you, Madam Chair. Good afternoon, Eric Stafford with the Kansas Chamber. Good timing. My watch said it's time to stand up. So if you guys need to stand and take a break, feel free. So yeah, appreciate the opportunity to kind of provide a little bit of perspective. I did send out kind of a summary on some proposed changes to the kind of what I will call the master bill of the LLC updates that study group had been working on. So dating back to 2012, when Rob Bruckman was in the legislature, he probably went up to everybody a good 15 times. Hey, you guys need to support the Series LLC bill. And so I didn't know what he was talking about. So we sent it out to our membership and tried to get some feedback, and everybody's like, nah, seems fine. I mean, not really anything to do. It seems pretty in the weeds in terms of this new business structure, but we didn't have any feedback on that. And now we do specifically. So I don't have any comments about the changes that they're proposing, but I do have some comments that our folks are working on specifically related to Series LLCs and what we are getting member feedback on now that they'd like to see is this overall modernization is being considered. So page 2, I did send out some what you can call testimony, informational testimony that you guys should have a PDF copy on, and page 2 kind of covers that. So the best update or explanation, I need a Series LLC for dummies, and had our member explain it, and he said, if you think of a Series LLC, think of a condominium, and each unit within that building is a series underneath the main entity, underneath the main LLC license. And so the benefit of having that series structure is allowing the individuals who are licensed and the entity that is licensed in certain industries to operate under one main license. So each individual series doesn't have to go and get independent licensure in each state that they operate in. So there is a cost savings, there's an efficiency, time savings that businesses would achieve in accomplishing these changes that are being proposed here today. And so in that process, and we've been in communication with the Bar Association, we've been in communication with the Bankers Association. The Bankers Association was really concerned about loans and debts for a series and who is responsible if one of those series went under, and who can be obligated to pay. And so we worked with them late December, January to hammer out some language, and that is included. I believe it's the last section. Kelly's here, and she'll probably speak more to what the driving concerns were for their membership. But we worked to get to a point where they could be comfortable with the language that we're also seeking to have added into this bill. So the biggest key that we have is the changes in those 4 or 5 sections of statute that would be in addition to the work that the Bar Association study group has put together. But our feedback that we're getting and requests from our members within our organization is that these changes would help them specifically here in Kansas. And from my understanding, these are very close to the existing law statutes in Missouri related to series LLCs. I think that pretty much summarizes what we're after in terms of informational hearing. We can get into more details if need be, but as you guys consider the main bill, we would, bless you, as you consider the main bill, we would ask that the committee consider these amendments as well to help modernize and what our feedback has been on the series LLC side of things. So happy to answer any questions when appropriate, Madam Chair.
Okay, thank you. So just to confirm, the amendments you're proposing are just for the series LLC piece of it.
Yes.
And you mentioned you had talked to the Bar Association, and I suppose when we have actual testimony, they'll say what they're thinking, but are they in agreement with your language? Or, sorry, maybe we should wait till the hearing, but.
I think it's fair to say they're not necessarily in agreement. Joe, is that fair? No. Oh gosh, I love Joe. Yeah, so I think they're not necessarily in agreement.
Okay, we'll get into that then next week.
Yes, thank you, Madam Chair.
Okay, thank you. And I'll now call up Kelly Vanswall from the Kansas Bakers Association, the other KBA. It's hard for us to keep them straight.
That honestly did cause some confusion in our earlier discussions. But hello, Madam Chair Committee, Kelly Vanswall with Kansas Bankers Association. Thank you for the opportunity to talk about this today. As was mentioned earlier, the Bankers Association has always been involved in the LLCs and the series LLC discussions because it affects our handling when we are dealing with these business accounts of tracking not only debt, but also it has to do with like their tax ID status and a lot of other factors that come into play when we're banking these accounts. I actually think one of the reasons for requiring the filing with the Secretaries of State's office back in the day was a complaint on our end. So I'm happy to see that one paid out in the long run. We appreciate the Bar Association for constantly looking at these and working hard to update them. In general, we are supportive of the Delaware model for all the reasons that the earlier the earlier Bill Quick testified on. We appreciate the case law. We appreciate that Delaware's the expertise on this, and we can look to all those court cases to know exactly how this law is going to be understood and read. So for us, and particularly with bankruptcy cases, that means a lot. When the chamber reached out to us about their amendment on the series LLC piece in particular, we decided that if the legislature is comfortable moving away from the Delaware model, then we wanted to work with them to be able to get comfortable on their amendment. So I don't know if that's clear enough for you all, but we support Delaware. But if you all decide to move away from Delaware, we wanted to work with them to kind of address some of our concerns with their language, and we appreciate them for working with us on that. One of our concerns was the ambiguity. I've had a long day today, folks. Sorry, guys. Ambiguity of if a series LLC is acting independently or jointly. So that's something we discussed with them in their language. And we also talked about adding language to address fraudulently moving collateral between the series. That's something we really worry about. And so we referenced the Kansas statute that has to do with the fraudulent transfer. We weren't sure if the current Kansas statute would already cover the series LLCs, so that's why we wanted it referenced in there. And we also worked with them to narrow their tax language down to just a shared tax status for the purpose of consolidated filing. They said that's why they wanted the shared tax status, and we understand that, but the reason the tax status matters to us is if there's a garnishment or a tax levy that comes into the bank, we match it based off your tax ID. So if they all share one tax ID, we'll have no way of knowing who to actually put that garnishment or tax levy on. So that was kind of one of our concerns that we worked out with them. And I know this is just informational, so we can dig deeper into all of that when we actually have the hearing in the language. But happy to take any questions.
Okay, thank you. Committee, do you have any questions for any of the three folks that are giving us the informational hearing today? Representative Carmichael?
Thank you. Questions for Mr. Stafford, please. Mr. Stafford, my understanding is that the Chamber's recommendations come from one Chamber member, and the lobbyist that you've been sitting with represents them. Why is the Chamber disregarding the good advice of the Kansas Bankers Association, Mr. Quick, Mr. Matthews, some of the preeminent commercial lawyers in this state? Why is the Chamber taking a different position based upon the recommendation of, as I understand it, one member?
Well, I don't think we have, thank you for the question, Madam Chair. I don't think series LLCs are heavily utilized, but for those who use them, I think it's important to how they're structured. And I think for this, and specifically to this company that you're referring to, I think it's working well for them, and I think they are willing to be a partner. Series LLCs are state laws in this case, and I think we're trying to cover the bases that of concern that are out there. But I know Delaware has case law that are specific to Series LLC, but again, we're dealing with state law, so I don't know how much this diversion would be in the sense of the language that is being added. It seems pretty clear. It's clarifying the structure of the business entity, but states have various laws across the board. I don't know what Delaware's work comp statutes are. I don't know what their child care policy laws are. I don't care what unemployment insurance laws are in Delaware. I care about Kansas policy. And for this company that likes Kansas and wants to like Kansas better, they're concerned about Series LLC laws in Kansas. And this is their recommendation and their suggestion to make it successful for their business model to be able to successfully operate here in the state.
Madam Chair, my second question is for either Mr. Matthews or Mr. Quick.
Okay, are you all still there on WebEx?
Yes, I'm here.
Okay, thank you. We have one question from Representative Carmichael.
Mr. Matthews. Hello, Mr. Matthews. Can you hear me?
Yes, I can. Good afternoon.
You've heard what Mr. Stafford just explained. How,
Yes.
if at all, does Kansas adopting an unusual or different serial LLC scheme impact the ability to attract companies to Kansas and you and Mr. Quick's ability to represent clients from all over the nation who want to come to Kansas?
Well, as Mr. Quick, again, good afternoon, committee. My name is Bill Matthews. I'm a partner with the Folston Sievkin firm in our Wichita office. As Mr. Quick explained at the beginning of his testimony, the policy in Kansas formally for 50 years, over 50 years, since 1972, and actually even informally before that, is to model our business entity laws after Delaware. We don't slavishly adhere to Delaware, but we adhere closely to Delaware in our business entity laws to gain all the benefits that adherence provides. Rich body, at the cutting edge of understanding and business entity laws, the rich body of excellent case law by specialty judges who only decide those case law cases. And so the concern about varying from Delaware but in particular varying from Delaware where there is not a clear need or justification, that's concerning, because of course once we start varying from Delaware, then we lose the benefit, then we lose all of those benefits. I will also say that I take a little issue with the comment that was made earlier that there would be a need to seek to modernize our series LLC scheme in Kansas. As we said before, Delaware is absolutely prolific in updating its business entity laws generally, and specifically in the LLC statute. Again, every term, the Delaware legislature passes amendments informed by changes in federal law, case law, input from bar and businesses throughout the country, all of which form Delaware entities. And as a matter of fact, just in the last session in Delaware, there were significant changes in their LLC structure, which we are attempting to replicate in our bill. So there cannot be more cutting edge law and understanding in business entity law generally, but in particular in series than there is in Delaware. So that's why it's our very strong preference to adhere to Delaware law, so we can gain all the benefits that we have as a matter of Kansas policy, recognized by the legislature and through our courts for all that time.
Thank you, Mr. Matthews. I'd be happy to stay here for 2 hours actually and discuss this with two of the finest corporate lawyers in the state of Kansas, giving their time to us for free. So I'm happy to stay and do this.
We do appreciate them being with us. Any other questions, committee? Yes, Representative Bohai.
Thank you, Madam Chair. Mr. Stafford? Hi there. Thanks for your testimony today, or your information today. I understand Delaware seems to be the gold standard for LLC law, and I can appreciate that. Are there other states that are currently using the series LLC scheme, for lack of a better word at this moment?
There are. I can't tell you all of them off the top of my head. I can do some research and get that to the committee for sure. But I will say again, I think these provisions are very close to Missouri that we're asking to be included. So in terms of attracting business, I think Missouri is attracting business. I think Missouri's sky is not falling with the structure that they have in place. And even though it's diverting from what is considered and being called the gold standard of Delaware and the case law that goes behind it, I think they saw merit, they approved it, they adopted it in Missouri, and that's what we're seeking to have included here in Kansas as well.
Thank you.
Thank you, committee. Any other questions? Okay, thank you, everyone. I will close the informational hearing on our update to our limited liability companies. And we will have that bill hearing next week is what the plan is, as long as we get the bill and get a bill number and get it referred to our committee. So thank you. Committee, we are going to take action on 2 bills right now. We'll see what happens. I don't anticipate that it's going to be a lengthy discussion, but that's going to be at the wish of the committee. So first we're going to look at HB 2181, and we'll have Natalie give us 2182. We'll have Natalie give us a short description and brief.
Sure. Thank you, Madam Chair. House Bill 2182 prohibits the sheriff from charging a fee for service of process for proceedings under the Protection from Abuse Act and the Protection from Stalking, Sexual Assault, or Human Trafficking Act.
Okay, thank you. Any questions for the revisor? Okay, do we have a motion on HB 2182? Representative Williams.
Thank you, Madam Chair. I move that we pass House Bill 2182 favorably for passage.
Do we have a second?
Madam Chair, I have it.
Sorry. Yeah, hang on just one sec. Do we have a second on the motion? Second. Representative Osman. Okay, do we have discussion or amendments? Representative Ward.
Madam Chair, I have an amendment.
Okay, well, we do have paper copies, so while she's passing that out, would you like to explain it to us?
Madam Chair, my amendment clarifies that a PFA or PFS from out of state would also not be subject to a fee.
Okay, thank you. Would you like to make a motion for this amendment?
I move my amendment.
Okay, is there a second on the amendment? Representative Barr seconds. Okay, any discussion or questions on this amendment? You can have a moment to read it. Representative Carmichael.
Thank you, Madam Chair. If I might inquire of the maker of the amendment, my assumption is that this has been run by the Kansas Coalition Against Sexual and Domestic Violence and that they support this amendment. Is that a fair presumption on my part?
Representative Ward.
Correct.
Thank you.
Any other questions on the amendment or Representative Barth?
Yes, Chairman, I would like to have further explanation of how that would work with out-of-state. I'm interested in, I understand what a PFA is now, and not everybody maybe understands that. So if you could explain, and then how an out-of-state one would apply in Kansas. Is it a transfer of how that would not have a fee?
So Representative Ward, if it's okay with you, I know there's someone here from the coalition that would probably be able to answer that, if that's okay with you. Yeah, okay, go ahead, please, thank you.
Members of the committee, Michelle McCormick, Executive Director of the Kansas Coalition Against Sexual and Domestic Violence, and happy to describe that a little bit further. Protection orders are universally recognized so no matter where you file a protection order in the country, they get recognized and are effective in every state. And so in some jurisdictions, there is a requirement for a sheriff's office to go register your protection order so that they know that there's a protection order in place. And so a survivor would go into a sheriff's office and basically present the paperwork and let them know. But also when protection orders are filed and they're finalized, they're entered into the NCIC, the National Crime Information Computer, so that any law enforcement official in court can pull up that information and see that it's in enforcement. And so, so any out-of-state order, sometimes so for example, this happens frequently where a Missouri protection order, the folks in Missouri will ask a favor of a Kansas law enforcement agency to serve it, against a respondent in Kansas. And so they provide the paperwork and make that service so that it is in effect, but they basically do that as a favor to each other. So hopefully that answers your questions.
Representative Barth, did you have a question?
I did. I just wanted to make sure and how she described it. Not you, Michelle, but thank you for that. How Jill described it. I'm just making sure I understand the reading, how that applies to how you described it as well. Thank you.
Representative Ward.
Correct. It does.
Yep. Okay. Any other discussion on the amendment? Representative Ward, did you like to close on your amendment?
Yes, I close.
Okay. You've heard the amendment for House Bill 2182. All those in favor say aye. Aye. Opposed, no. Okay, we have the amendment on to the bill. And now any other amendments or discussion on the bill? Okay, since we don't, Representative Williams, would you like to close on your motion?
I move that we pass House Bill 2182 as amended with favorability for passage.
Okay, you've heard the motion. All those in favor say aye. Aye. Opposed, no. Would anyone like their vote recorded? Representative Carmichael? Anyone else?
In the affirmative, Madam Chair.
Yes, yeah, thank you. Appreciate that. Okay, all right. Then we will send that on. Now we're going to take a look at House Bill 2166. Do we have a motion, Representative Williams?
Thank you, Madam Chair. I move that we pass, and should I add that now? Yeah. I just want to bring up, due to its non-controversial nature and that it's with the revisor's office and according to statute. It's that one,
I'm
right?
sorry, Natalie, would you explain to us what this is about first? I'm so sorry, you all, I forgot that. Forgive me.
Thank you, Madam Chair. This is the most exciting bill that you're going to hear all year, so I can't believe you skipped the bill brief. House Bill 2166 continues in existence the exceptions to the disclosure of public records under the Open Records Act that are due to expire on July 1st of this year.
Any questions for the revisor? Okay, now I Representative Williams.
Okay. Am I allowed to state, due to the non-controversial nature, I recommend that we move House Bill 2166 favorably for passage and onto the consent calendar.
Do we have a second? Representative Bourgeon seconds. Discussion, Representative Carmichael.
Thank you, Madam Chair. I move that we divide the motion because I do support the bill, but I do not support placing it on the consent agenda.
Would you like to make a substitute motion?
I think it's technically, it's a motion to divide the current motion into two separate sections. One, do we pass the motion? Two, do we do it by consent? But maybe if you want a substitute motion, the substitute motion is simply that we report the bill favorably for passage.
Is there a
That'll
second
work.
to Representative Carmichael's substitute motion? Representative Vaughn seconds. Discussion on the substitute motion to just pass the bill out favorably. Representative Osman.
Thank you, Madam Chair. While I have no strong opinions one way or the other, I will say that allowing us debate on the floor gives one of us fine members a wonderful opportunity to explain Cora in much more detail.
Very good. Okay, any other discussion? Committee, I just would encourage you to vote either way. Whatever you would like on this one is perfectly fine. Representative Carmichael, would you like to close?
Certainly. Close on the motion. Number one, as a practical matter, we have new members who need to be warmly greeted to the Kansas Legislature, and we want an opportunity for them to have that opportunity. Number two, I really don't like what goes on with the consent agenda. If I fail, the principal motion passes, I'll object the first day, and we'll be back to where we were before.
Okay, thank you for that. Did you close?
I close and move my substitute motion.
Okay, thank you. You've heard the substitute motion. All those in favor say aye. Opposed, no. I believe the substitute motion passes. Yes, on the amendment.
On the substitute
substitute
motion
amendment.
that just passed, we're done. It's
Okay.
passed.
Oh, yes. Oh, did I ask for discussion?
No, you didn't. Do you want to have some?
I think we discussed it well enough. Okay, yes, your affirmative vote. Anyone else would like their? Okay, then we have passed House Bill 2166 favorably for passage onto the full chamber. Okay, committee, we will not meet tomorrow. I do fear that we're going to have to meet next Friday because there's still just some things we don't have yet. So please put that on your calendar. We'll do everything we can next week to work hard, have busy days, and not work on Friday. But at the moment, I think we should go ahead and put that on your calendar. So, okay, any other discussion for the good of the committee? Okay, with that, we're adjourned. Thank you for good work today.